the RIF roadmap, RIF being reduction in force, tools and tactics for a smooth and compliant transition. We regularly provide webinars for our clients and friends, and all of the lawyers in the labor and employment and compensation practices at Foley have noticed a strong uptick in requests to help plan for reductions in force, separation agreements, etc. And thus we thought this topic would be timely for today's presentation. Today's presenters, you'll hear first from Carrie Hoffman. Carrie is a partner in our Dallas office and is also the chair of the Labor and Employment Practice at Foley and Lardner. You'll be hearing from John Birmingham. John is a partner in the Detroit office and comes to you from America's manufacturing heartland and has years and years of experience in restructurings both in union and non-union environments. Next is Lee Riley, a partner in our Milwaukee office from our Benefits and Compensation Practice, who will be providing insights and information on that topic. And last but not least, Ann Seckel, partner and office managing partner of our New York office, will be talking about WARN and other regulatory issues that impact your decision making. And so with that, Carrie, take it away.
That's right. So as Mark indicated, we have been hearing a lot from clients over the last few months that their business is in somewhat of a state of flux. We have ever-changing economic indicators. Each day it seems to change as to whether all is going to be good, all is going to be bad. Are we going to have tariffs? How are they impacting the economy? And so lots of clients have been telling us that they're in the midst of reevaluating their workforces and their employee needs. And our goal today is to provide you, if you're in that same state, a comprehensive guide on RIF planning, from how to implement the RIF, to comply with the WARN Act and the states that have, we call them mini WARN Acts, although as you'll hear, New Jersey isn't quite so many, severance agreements, the benefit implications that come along with reductions in force and severance agreements, and some do's and don'ts. We're also going to, if you go to the Q&A box in your screen, you can ask questions that we'll answer either as we present or at the end of the program. And with that, I'm going to turn it over and let somebody present on the WARN Act and mini WARN Acts. I believe that's you, John.
Yeah, that's me, Carrie. Thanks. So I'm going to present on the WARN Act, and then Ann is going to cover the mini WARN Act. So I guess, first of all, the WARN Act is probably the first thing to think about when you're conducting reduction in force planning. And why is that? Well, the main reason is you need to give, if WARN is triggered, you need to give employees 60 days advance notice of the employee termination. And that's important because, 60 days is a long period of time. And you'll hear me say this a couple of different times. WARN really requires you to keep track of when you might trigger WARN and to keep track of the timing, because each day you don't provide the 60 days notice, if you do trigger WARN, is a day that you owe money. And I would say there's a couple of big reasons why we should care about WARN, right? First of all, the liability really adds up. So if you don't give, with some exceptions and some defenses, if you don't give a WARN Act notice, then you will have to pay the employee not only the time period when you should have provided the WARN Act notice, but you could also be on the hook for medical expenses and fines from the state. So the numbers really add up. Secondarily, it's very susceptible to class treatment, right? Because if you don't provide the appropriate WARN Act notice to employees, you're not providing it to all the employees who are involved, right? So a mistake with respect to one employee is a mistake with respect to all the employees. So it's very susceptible to class action, collective action treatment. And the third thing is, if you screw up the WARN Act at the beginning, there can be negative publicity and it can have a real effect on employee morale. So you really want to make sure that you keep your eye on the ball with respect to WARN. The basic requirement of the WARN Act is that if you're a covered employer, if you have 100 or more employees, you have to give 60 days advance notice of a plant closing or layoff. So relatively big employers should give covered employees 60 days notice in two circumstances: when it's a plant closing or when it's a mass layoff. That seems fairly simple, but it is not always so simple. Really, covered employees, both salaried and hourly employees, whether you're the CEO of the company or you are a union employee, as long as you're an employee, you are covered by the WARN Act, right? And there's two different issues with respect to coverage, though, and I'll talk about that in just a second. And that is which people are employees for the purposes of triggering whether the WARN Act is at issue. And then secondarily, who is an employee with respect to being entitled to the notice itself, right? So anybody who's in a salaried or hourly employee is going to potentially qualify for WARN. If you're an independent contractor, you're not. And if you're a temporary employee, you're also not going to be entitled to notice, but there's a wrinkle there that I'll explain in just a second. So again, two different ways that WARN is going to be triggered. The first way is the plant closing. And a plant closing basically is any situation where there's 50 or more full-time employees who suffered an employment loss during any 30-day period. Keep your eye on the 30-day period, though, because I'm going to get back to that. It really is not a 30-day period. It's really a 90-day period, and I'll talk about why. A plant closing is basically any situation where you have a permanent or temporary shutdown of a single site of employment. Keep your eye on this practice tip. Sometimes you can have a plant closing when a unit of your facility is shut down. So, for example, I do a lot of automotive supplier work. There are some facilities that have seating. They manufacture seats and also manufacture interiors, like overheads. And if you were to get rid of one component of that, let's just say you got rid of the seating component, that in and of itself could be a plant closing. And if 50 or more employees are being laid off, you're going to trigger WARN. So part-time employees are, this is, the government, of course, makes this complicated, right? So part-time employees are not included when you're calculating the 50-person threshold, right? But they are entitled to notice. So they're not included when you're adding up whether or not the 50 people have been terminated. But if the 50 people have been terminated to trigger WARN, then they are entitled to an actual WARN Act notice. And sometimes, the details really matter here, because you have a situation where, somebody hasn't worked, 6 of the last 12 months, or somebody's working 20 hours or less a week, and so they shouldn't be counted. And, sometimes it gets down to the nitty gritty where it's a difference between, well, are 45 people being terminated or laid off, or do we have a situation where 50 people are being terminated or laid off, right? Temporary employees, they are included when you are calculating whether or not the 50-person threshold is met, but they are not themselves entitled to WARN Act notice. So it's clear as mud, I know, but just keep in mind, part-time employees get WARN Act notices, temporary employees don't. Temporary employees are counted when to determine the threshold, part-time employees are not. Second situation when you might need to give a WARN Act notice is when there's a mass layoff. There are two situations where there's a mass layoff. The first is, and sometimes people forget about the second part of the first test, if 50 employees are being terminated or laid off, and those 50 people constitute 1/3 of the workforce. So if you have 150 employees and 50 people are being laid off, that's a mass layoff. If you have 200 employees and 50 people are being laid off, that's not a mass layoff, because that's not 1/3 of the workplace. Kind of the default issue, though, if you lay off 500 people, then regardless of the percentage, it's going to trigger the WARN Act. One thing to keep in mind with respect to the WARN Act, it's very location focused. So sometimes people confuse it. They say, oh, we are doing a mass layoff, but it's a mass layoff involving a number of different plants. Unless the plants are adjacent to each other, and it can get very complicated whether or not they should be considered together, really, you should look at the site of the layoffs themselves to determine whether or not WARN is being triggered. So if you have another plant that's 10 miles away from the first plant, those two should not be aggregated. So you could have 20 people being laid off in one plant, 30 people being laid off in the other, and you would not be triggering WARN. This is something to really keep in mind because the text of the statute says you look at 30 days, but the reality is when you look at the regulations, if 2 or more groups of employees are laid off during a 90-day period, unless you can show that there are separate and distinct reasons for the layoff decision and you're not attempting to evade WARN, then they should be considered together. And that's super important because it really demands that you look both backwards and forwards, right? So, for example, if you lay 10 people off in June, right, and then lay off 40 people in July or August, that means the 10 people that were laid off in June should have received the WARN Act notice, okay? And so that really requires you as HR professionals, lawyers, as business people to look forward and to try to figure out within a 90-day period, am I going to be triggering WARN? Because if I am, then I need to, the first round of layoffs, I need to give people the WARN Act notice. So back to my example, if people in June, the 10 people in June should have received a WARN Act notice, you have to go all the way back to April, right, to give them 60 days notice, even though the reality is it's not until August when you're really going to meet the threshold. So it really requires advanced planning. I am not a big spreadsheet person, but this is an area where it's really valuable to have a spreadsheet and to refer to it from time to time to make sure that you're on track about whether or not you are triggering WARN and what it looks like. Employment law is defined. I mean, again, there's a lot of litigation over all of this stuff, but if somebody quits, they're not counted with respect to triggering WARN. If someone's discharged for cause, they're not counted. If someone retires, they're not counted, right? If someone has a layoff of less than 6 months, they're not counted. If someone has a reduction in hours of less than 50%, they're not counted. So it's all dependent upon the facts of the situation, and sometimes it gets very much litigated. We're going to talk in a little while, I think, about the benefits of a voluntary reduction in force. One of the benefits of a voluntary reduction in force is it can prevent you from triggering WARN if someone is volunteering for it. But there can be a lot of uncertainty about whether or not an employment loss occurs. Recipients, I mean, it really doesn't matter that I should say technically under the statute, right, the recipients and contents of the notice, it can be in a variety of different ways. I mean, I would say you're much better off to have a standard WARN notice where you actually mention WARN in the letter to the employees, but that's not required under the Act. You can do it in a number of different ways. You've got to deliver it. You got to make sure that people get it within the 60-day time frame before their termination. If there's a union involved, you need to make sure that you give the WARN Act notice to the union employees. If there's no union representative, each individual covered employee gets a WARN Act notice. So does the state dislocated worker unit. That's really most of the time just another word for the unemployment agency in the state where the terminations are occurring. And then also the chief elected official of the local government unit where the plant is or the facility is also gets a copy of the WARN Act notice. Just exceptions to the notice requirement. There are a few different exceptions: closing of temporary facilities, strikes or lockouts, which are bona fide labor disputes. And the next two, I think, are the two that get litigated, and we see more often: a faltering company situation. So in a plant closing environment where if you could get financing and giving the WARN Act notice would prevent you or arguably prevent you from getting financing, that can be a reason to delay the WARN Act notice. The unforeseeable business circumstances, that's an even more prevalent exception. And that could be a situation, I'll do it from the automotive supplier standpoint, when a customer might tell you that they're ending a project or you're losing business from the customer. And if you can show that it was unforeseeable that this was going to happen, it can give you an exception or a defense to not issuing a WARN Act notice on a timely basis. The thing to remember, though, about all these exceptions is that it just delays the time period when you should give the WARN Act notice. It doesn't eliminate the need to give the WARN Act notice. So, for example, at some point in time, you're going to hear from the customer that you're not going to get the business anymore. And so that might enable you to give 30 days notice instead of 60 days notice. And you would be excused if you could prove it from giving the 60 days notice. But once you know for sure, or once it's reasonable, not know for sure, once it's reasonable that you're going to be losing the business, then you've got to give the WARN Act notice. I'll turn it over to Ann to talk about mini WARN.
Thanks, John. So as you can hear from John, WARN Act issues generally are, complicated, and there's a lot to them. The same at the federal level, the same is definitely true at the state level. The WARN Act in New Jersey has the very complicated and non-descriptive name Millville Dallas Aeromotive Plant Loss Job Notification Act, which doesn't let you understand anything about the actual act. All you need to know is that that is the name of the WARN Act in New Jersey. It applies to individuals, it applies to businesses who have 100 or more individuals employed by them. Full-time and part-time both count towards that 100 number. And the other thing to keep in mind is in New Jersey, the definition of covered employer is quite broad. And it includes any individual, partnership, association, corporation, person, group acting indirectly or directly in the interest of an employer. The bottom line is to think expansively when you are considering whether you are a covered employer and whether the employees that you're looking at are count towards the 100 employee threshold. The Act requires covered employers to provide 90 days written notice when there's going to be a transfer of operations or a termination leading to 50 or more employees within a 30-day period being terminated, or if there's going to be a mass layoff, and those are the same numbers, 50 employees within a 30-day period. The notice has to be given to a variety of different individuals and entities. The thing to remember in New Jersey is that the New Jersey Department of Labor and Workforce Development is among those entities, but they have some very convenient and set forms on their website to allow you to provide the various notices to all the different individuals. And that form should be followed. And as I said, it kind of streamlines the process. New Jersey is very stringent about severance and about penalties for non-compliance with WARN Act obligations. So regardless of whether notice is given, if you have a triggering event, the employer must provide 1 week of severance for each full year of employment for all affected employees. On top of that, layered on top of that, is a situation where insufficient notice is provided, and in that case, the employer as a penalty must pay an additional 4 weeks of severance. And this is true whether or not the employer provides no notice, so 0 days of notice, or if the employer falls only 1 day short of the 90-day period. So for example, if you give 89 days of notice, you still owe the same penalties as if you gave no notice whatsoever. So it's really a very strict penalty. I won't go through all of the differences between New Jersey and the Federal WARN Act, but I will highlight a few. One is that there is no faltering business exception. So if you are in a situation where you lose a customer, you're looking to gain more capital or investment, and giving notice will jeopardize your ability to get it, that does not count as an exception. Really, the only exceptions in New Jersey are natural and other similar disasters, so fire, flood, act of war. The other thing I wanted to draw your attention to was the fact that under New Jersey law, there's really quite a bit of expanded assistance that is given and information that's provided to affected employees, including information about programs at the state level or otherwise that may actually intervene and prevent or delay the closing of an establishment. So it really is significant. Moving on to New York, which it looks a lot more like the Federal WARN Act. This act is found at New York Labor Law, Section 860. It applies to private sector employers that employ at least 50 full-time employees. So part-time employees, those who are working 20 hours or less, or who have been employed for less than 6 months, they don't count towards it. But the employees do need to be either in New York State or work a total of 2,000 hours per week in New York State in the aggregate. The New York Act requires covered employers to provide 90 days written notice before a plant closing, a mass layoff, reduction in work hours, or a relocation of substantially all facility operations. The numbers that are associated with those are generally for a plant closing, it's 25 employees who are affected. For a mass layoff, it's 250 employees or 25 employees if they comprise at least 33% of the workforce. And the same is true for the relocation. A reduction in hours means a reduction by more than 50%. Their notice needs to be given to, again, a variety of different individuals and entities, of course, the affected employees, the New York Commissioner of Labor. The type of notice, the information that should be included in it varies depending on the recipient. So it is always a very good idea just to check what the requirements are for each individual person to whom you're giving notice. The penalties for noncompliance under New York law, again, very similar to the federal penalties. It's $500 a day applied in the aggregate and not per employee. Back pay. The value of the benefits the employee would have received had they not lost their employment, including notably any medical expenses incurred that would have been covered by a benefit plan. And other than differences in terms of the notice period and the covered employer size and the layoff threshold, the framework of the New York WARN Act is very similar to the its federal counterpart. And finally, looking at California, which is the other jurisdiction in which we see a lot of reductions in force, the WARN Act in California is found at California Labor Code Section 1400. It applies to employers who own and operate facilities with at least 75 employees, and it requires 60 days advance written notice for a mass layoff, a relocation, or a termination. Two exceptions just to note in California. One is for certain project-based work in broadcasting, motion pictures, logging, mining. So if the employees understood at the time that they took a job in those particular industries that the project would be of limited duration, there is no WARN Act notification requirement. And the second is the faltering business exception. No notice is required if an employer can show that they were actively seeking capital, actively seeking an investment, and that giving notice would have prevented them from obtaining the capital. Finally, almost identical to New York. In fact, I think it is identical, and federal penalties, $500 a day, back pay, the value of benefits that the employee would have received. And of note is that liability is calculated for the shorter of the period of the employer's violation, up to 60 days or 1/2 the number of days that the employee was employed. And with that very quick walk through the mini WARN Acts, I will turn it over to John again to talk about unions and RIFs.
Before we switch gears, and we've got a question in the chat. You briefly mentioned the faltering company exception, but we have a question. Does bankruptcy in itself stay or prevent an employer from having to give WARN notice?
It does not prevent the employer from having to give WARN notice. The mere fact of bankruptcy, it could conceivably play a role in the damages that might be allocable to the company, but in and of itself, the employer needs to still give a WARN Act notice even when they're declaring bankruptcy. Great. So just quickly, I'm going to cover a few issues with respect to the RIF considerations in a union environment. A couple of just last final things on WARN. You can release WARN Act liability, right, through a potential severance agreement and release. You can pay in lieu of providing the notice. That's a little risky with respect to economic damages. And the good news is it's WARN Act liability is limited to economics. There's no emotional distress. There's no punitive damages. However, the medical expense issue can really be something that's a surprise for a company. If somebody, let's say they have a huge operation, that could be hundreds of thousands of dollars, right? Or multiple people. So again, there's still pretty high potential liability. With respect to unions, okay, I'm going to cover this fairly quickly. So questions: must the employer bargain if there's a decision to conduct a reduction in force? Usually no. Usually the company does not have to bargain over the decision because it's typically within the management rights clause. But if labor costs are the reason for the reduction in force, or especially, let's say, for example, you're moving some of the business to another country, to Mexico or elsewhere, and it's labor costs that's the reason for the reduction in force, then you very likely will have to bargain and give the union the opportunity to reduce the wages and costs that are precipitating the decision itself. If not, must the company bargain about the effects? Yeah, typically the company has to bargain, or the company will have to bargain about the effects of the reduction in force. Typically what that means is if the company is going to pay severance, right, or what's going to happen with respect to the plant closure or the reduction in force. The company is not obligated to pay any specific amount of severance unless the collective bargaining agreement itself provides for severance or a specific amount of severance. And that can happen, or that can be part of a collective bargaining agreement. So if it doesn't, then you have to bargain with the union about the potential effects of the reduction in force or the layoff, but there's no obligation to agree to any specific severance. Even if there is no obligation, even if there's no obligation to bargain over the decision to conduct the reduction in force, I think from a practical perspective, it is good, though, to meet with union leadership at the appropriate time before the decision is announced to employees, just from a practical perspective, and to help ease what was going to be obviously something that is very stressful for the employees and could damage union relations. You still want to communicate to the union at the earliest possible opportunity that the reduction in force is occurring or the plant closing is occurring. With respect to the selection process itself and the economic consequences itself, a lot of times the contract will provide both information about the selection and the economic consequences. And anybody that deals with the union environment knows that unions love seniority. And so typically the reduction in force or the plant closing will have to be made with respect to union employees based upon seniority. And that's usually going to be in the contract itself. Okay. If it's not, then you have to potentially bargain over the effects. The contract also may provide how much severance you need to pay employees with respect to it. I always try, though, if you're negotiating about the effects of a plant closing or reduction in force, that you not only come to an agreement with the union, a plant closing agreement, but as part of it, the employees also sign individual waivers and individual releases to prevent lawsuits over the reduction in force. With that, I'm going to turn it over to Lee Riley.
Thanks, John. So we're quickly going to go through some benefits and severance pay issues to consider. The first thing you do when you're planning for a RIF is to make sure you're surveying all of your existing plans. So do you have a severance pay plan already in place that would apply? Do people have employment agreements that would have severance benefits? Also make sure you pay attention to other documents like your bonus plan. Do you have to pay out bonuses to people who are terminated without cause? Or are there non-qualified deferred compensation plans that would pay out on a termination? Once you do this then, and you identify the people who will be RIF'd, you've got to come up with an estimated cost and make sure you let your CFO, who's going to be very interested in this, know what the total cost of this RIF is going to be for the company, paying particular attention to anything that's going to get paid out in a lump sum, because that's a cash outflow that your business leaders are going to need to be planning for. And if after you're looking at these documents, you realize we can't maybe afford the benefits we've got in place, then you check to see whether you can amend the documents to reduce the benefits so that they can be affordable. If you don't have an existing separation pay plan in place and you're not required to have one outside of the WARN context that we just discussed, it is typical though to provide it in a RIF situation. And we like severance plans to be in writing for a couple of reasons. Number one, it sets the expectations of your employees about what they'll be receiving. It also helps if you have multiple locations for your local HR and your plant managers to understand the benefits that you'll be providing so that everybody is speaking in a unified voice. Severance plans typically have three components. Of course, severance pay, which often can vary based on position or years of service. It's totally fine to provide different amounts of severance pay. For example, you might see a plan that says for managers and above, they get 2 weeks of severance pay for every year of service. For people below the manager level, 1 week of pay per year of service. You also would normally specify whether pay is going to be made in a lump sum or over time, keeping in mind that payments over time are often great because it helps with cash flow situations. And then we often see minimums and maximums. No matter what, there will be a minimum of 4 weeks of severance pay or a maximum of 26 weeks, again, depending on what you can afford. Second typical component is healthcare coverage continuation of some sort. Like if you elect COBRA, you will only pay the active employee rates for coverage instead of the full COBRA premiums. Or maybe the healthcare coverage is going to be free for a period of time. That's very typical. I do like to ask companies to consider whether they want to do this versus just giving people extra cash, because you may not want to encourage former employees to stay on your medical plan. It might be that the medical benefits that you would provide could be more expensive than just providing some additional cash that the former employee can do whatever they want with. Finally, we normally see outplacement services of some sort. Again, those would typically have a dollar cap and some sort of time requirement. You got to use these in the first 6 months after you terminate employment. And of course, as we mentioned a couple of times, you want to make sure all of these things are contingent on getting that signed separation agreement and release. Now, another thing to consider is whether you first want to offer a voluntary severance program or an early retirement program. So these are programs where people can choose to quit and still get their severance pay. Normally it's a window of time, people make their choice, and then they get those severance benefits even though they're choosing to quit. You can limit these types of programs to people based on age and years of service. For example, only people who are age 50 with at least 5 years of service can opt in. You can also limit who gets made the offer. For example, this business unit or this location, but not that one. That's totally fine. You can say, but no more than 5 people from the accounting department. That's okay. People often get worried when implementing these programs. They're like, well, what if somebody accepts the program and they're a key employee and I can't afford to have them leave, right? I'll be in the lurch if that happens. You are allowed to say in your program that if somebody accepts a program, but you deem them to be a key person who you can't live without, you can decline their participation. Normally, the benefits need to be better than the ones you would be offering on an involuntary separation, because of course, we're trying to incentivize people to choose to leave the company rather than wait around and see if they're going to maintain their job or they're going to be the people who are RIF'd. The next thing to consider is whether your severance plan is subject to ERISA. ERISA applies if there is a sufficient administrative scheme in connection with the severance plan. And an administrative scheme means typically we're making payments over time, or there's judgment calls in determining who's eligible for the severance or how much they're getting. If you do have a plan like that, and most severance plans are ERISA severance plans, that's actually a good thing. A lot of times our clients say, oh, we don't want an ERISA severance plan. But as lawyers, we're like, we love the fact that this is an ERISA severance plan for a few reasons. So number one, the plan will have a claims and appeals process. So if anybody doesn't like the benefits they're getting, or they think you've done something wrong, they have to go through your internal claims and appeals process before they jump right to litigation. If you do end up in litigation, the judge only reviews what's called the administrative record, which is all the stuff you've prepared in that claims and appeals process. They don't look at anything else. And then finally, if you do lose the lawsuit, the judge can only grant the benefits that the plan provides, and in their discretion, the fees of the plaintiff. So we like ERISA status for that reason. Downside, you got to provide a summary plan description, but of course, a lot of times these documents are in writing anyway, so no big deal to turn that into an ERISA compliant SPD. And you might have to do a Form 5500 annual filing, but those are very simple for these types of plans. Here's a quick summary of tax issues. I'm not going to spend any time on this. It's just there for your reference. Couple other things to highlight is severance pay is never considered compensation for 401k plans. So please don't tell people that they can defer money from their severance pay into the 401k plan. That's not allowed. That's not a law. There's frankly nothing you can do about it. It's just the way the law is written. Sometimes we get asked, well, we have unused FSA balances. Can we just refund those to people? You cannot do that. That's also another legal rule. But you could, for example, allow people to spend down their medical flexible spending account balance. On the dependent care, it's a little harder to do because normally those are only to cover dependent care services while people are working, although technically they could also be used while people are looking for work, but plans often aren't drafted that way. And then my last point is, if you're promising any other kind of special benefits, like I'm going to keep your life insurance in place to the end of the year, make sure you're checking your life insurance or these other plan documents to make sure that we are not promising something that the insurance policy is not providing, because no surprise to you, insurance companies don't like it when we try to commit them to provide some benefits that they haven't agreed to.
There's a question in the chat. Can you explain more about how to spend down an FSA? I guess the answer is you go to Walgreens or CVS and you just stock up on everything. What's the real answer?
So medical FSAs normally have a COBRA obligation attached to them if there's a positive balance. So basically what I'm saying is you just sort of waive the COBRA. So what you would do is, let's say I've got, a $1,200 balance in my medical FSA at the point that I'm RIF'd. I haven't submitted any expenses. Of course, any expenses I incurred while I was employed can be submitted. That's normal course. But you could amend your medical FSA and say through the end of the year for expenses you incurred after you terminate employment, you can submit those as well.
Okay. So I'm going to take over and talk about selection criteria and severance agreements. I think in many ways, selecting who is going to be subject to a RIF is the most difficult aspect of it. There's lots of ways to go about selecting the individuals, and the path forward is not always clear based on the reduction mandate that you may have. For example, you may be trying to cut a specific amount of salary expense, and you need to work backwards to determine how to arrive at the requested savings without jeopardizing the structural integrity of the group or of the organization. That's a lot different than if the reduction mandate is to eliminate an entire underperforming business unit. But whatever the scenario, the most important thing is to really think carefully about the criteria that you're using and to use consistent and clearly identified factors. So the criteria can be either objective or subjective. Objective criteria is generally based on participation in a particular department or a geographic location or a job title. These criteria are generally concrete, pretty easy to identify and apply consistently. Subjective criteria is generally focused on characteristics that may be viewed differently depending on a personal viewpoint. So job performance, or perhaps someone's value to the organization, or a person's perceived ability to grow and develop with the organization after a RIF. If subjective criteria are used, it doesn't have to mean that the criteria is not clearly defined, but it will likely mean that you will have to work harder to articulate what those consistent standards are. So for example, if you're cutting underperformers or you're targeting underperformers for a reduction, perhaps you look to a concrete representation of performance. Some organizations assign a numeric score or a grade during yearly performance evaluations. That can be very useful to sort of convert that subjective criteria to something that's a little bit more objective. Maybe you're looking at individuals who've been placed on a performance improvement plan over the course of a period of time. Something that allows you to have a specifically articulable standard that you're applying across the individuals who may be subject to termination. Frankly, I think the hardest situation is where it's easy to identify some objective criteria and apply it, but the reduction that you're looking to make goes deeper, and you need to use additional subjective criteria to identify individuals. When you have that kind of hybrid situation, it creates some internal tension. Again, it really just requires some more diligence to make sure that those subjective and objective criteria are clearly articulated. After you've identified the initial list of candidates for termination, the work, unfortunately, doesn't end there. It really is very important to look at the entire pool of individuals and make sure that the articulated criteria were actually used and applied, because it's one thing to have a factor that you're looking at. It's another thing to apply that factor consistently. For example, if you look at a job title that was eliminated across different groups, but there's one person, an anomaly, there's one person who wasn't eliminated, you really want to dig a little deeper and make sure that that anomaly can be justified with a defensible business reason. And so for that reason and for other reasons, you really want to look across the individuals who have been identified for termination and to make sure that you can articulate the reason, and almost as though you're writing it down on paper, because you really should reduce the justification, the rationale for termination to a memo that you keep in your files. The final step, and I think one that's often done in a cursory manner, sometimes to an organization's detriment, is to do a disparate impact analysis. It is somewhat burdensome to do this, but it is well worth it in the end, I believe. Disparate impact, just to take a step back, refers to an unintentional discrimination that occurs when a seemingly neutral policy or practice disproportionately harms members of a protected group. And so the disparate impact analysis really requires an employer to look at the demographics of the organization as a whole, and then compare those demographics to those of the individuals identified for termination to see if there are individuals in the group that are disproportionately affected. I think the real question is what to do if you uncover a disparate impact. It doesn't necessarily mean you have to scrap everything and go back to the drawing board, but it is something that you need to go back and make sure that your reasoning is compliant for each termination, and have additional conversations to see if there is something that you can do to mitigate the disparate impact. These analyses will generally be discoverable in litigation should one arise from the RIF, unless it's conducted by counsel. Just very quickly on severance agreements, it is very important, as Lee said, to have a severance agreement where the terms of separation from the employer are articulated. It gives clarity to both parties. It includes the release, which is very valuable by the employee of the employer. At the very least, the agreement should always include the last date of employment and other information about the separation of employment. And you want to make sure that the release doesn't release any claims that may be precluded from being released by state law. Another issue that arises in connection with severance agreements has to do with the Older Workers Benefit Protection Act, which is a federal law that protects older workers, i.e. 40 and older, from age discrimination, particularly when it comes to benefits and severance agreements. And so what it requires is a release where there's been two or more employees over the age of 40 who have been terminated. You need to give 45 days notice and to consider the release before having it signed, and 7 days to revoke the release after signing it. 21 days is the standard if there's only one employee who's over 40. Under the Older Workers Benefit Protection Act, you also need to reference the waiver and the release of claims under the Age Discrimination in Employment Act, the ADEA. And there is a special disclosure that goes to the individuals that is usually appended to the separation agreement. It doesn't have to be, but it is generally an exhibit to the separation agreement, the severance agreement, which discusses the grounds for the termination. The last topic I want to touch on is unemployment benefits after a reduction in force. Obviously, unemployment benefits are administered on a state-by-state basis. They are not, in the first instance, the responsibility of the employer. Often, though, information about applying for unemployment benefits finds its way into a severance agreement. Sometimes a severance agreement may outline the process for applying for these benefits, or even state affirmatively that the employer will provide accurate and truthful information in response to an application for benefits. Some employers and some employees actually want the employer to go a step further and actually agree to cooperate in any unemployment benefit application, use that language like cooperate or not contest in any way. I generally discourage that kind of broad promise because it's really more than you need to promise as the employer. Saying that you will be accurate and truthful in response to any request for unemployment benefits or application is more than sufficient and appropriate. And the last thing is that in terms of the interaction between severance pay and unemployment benefits, it's really in the first instance the employee's responsibility in filling out an unemployment benefit application to disclose the existence of severance. And generally, it does vary state to state, but generally that amount will be taken into consideration when determining benefits. So with that, I will turn it over to Carrie, I believe, to talk about some do's and don'ts.
Yes, so we're going to just give you an overview of do's and don'ts when you're conducting reductions in force and the like. And big picture, and we're going to go through these in a little more detail, it's a really good idea to plan in advance, as we've been talking, especially when you consider both federal and state warrant issues. Train your HR department and business folks as to what the criteria are and be consistent with that. Make sure that you're documenting decisions. People leave and lawsuits can happen after they've departed. We want to conduct whatever disparate impact analysis we're going to do and have legal review. We want to make sure we're complying with OWBPA. And if possible, from an employee morale standpoint, we really want to get that done in one RIF as opposed to a series of RIFs where everyone's sort of looking over their shoulder. I did see a question in the chat as to whether companies still need to do disparate impact analyses given the current administration. And I think that may be confusing DEI and disparate impact analyses, which is disparate impact is saying, is there an adverse impact on a specific group, gender, race, et cetera? And Title VII would still give those employees that right, as opposed to the administration's current view on DEI. And with that, I'm going to turn it over to Ann and John to go through some more specific details.
Okay. This sort of goes back to the selection criteria issues that we were just discussing. And the fact that you want to have clarity, really good clarity on the factors that are being considered when you are looking to identify individuals for termination. It is permissible to use objective factors like seniority level or job title, and it is permissible to use subjective factors, so someone's performance, their value to the company. But in both those situations, the criteria really must be clearly defined and consistently applied. I hinted at this a moment ago when I was talking about the disparate impact analysis. In terms of whether or not you should do one when you are closing in on a final list of individuals, my vote is that you should always do this. I find that even where organizations have been very mindful of the RIF demographics during the selection process, which is not to say that they're using any sort of demographic as a selection criteria, but just mindful of who the individuals are that are in various different pools and classifications and thinking about who might be part of an ultimate RIF, even when that is in the forefront of their mind. They are still surprised and enlightened by the actual analysis, where you're doing a statistical comparison between the numbers of individuals in the organization as a whole and the ones that are in particularly affected groups. I think it's important from protecting yourself in the event that there is an issue down the line, and you do have a lawsuit that arises. If you have not cloaked that analysis in privilege, which you may have, it is a decision to think about whether or not you want it to be privileged so that you can take actions based on it without having that actual analysis be discoverable in the context of a litigation. But if you have something and it is exculpatory and then you don't want to treat it with privilege, it can be very, very helpful in the context of a litigation to say, actually, we did look at the impact to X group and it was fine and it was appropriate and it was proportional to their representation in the organization as a whole. So it's really something that, a theme that we've been talking about is just how much advanced notice is required before you're considering a RIF. It is part of that process where you really have to think hard and have the time, the luxury of time to think through all of these issues. Just thinking about whether or not you would include poor performers in a group that's being considered for termination. As I've said a couple of times, performance can be a legitimate factor to be considered. I think it's just very, very difficult when you're looking at, perhaps a variety of different evaluations of individuals where there may be inconsistencies in the way that a supervisor has written it, to try and distill that information down to something that is akin to a concrete criteria is challenging, but not impossible. And the last sort of, I think, do and don't in this category is if you're replacing the position, what do you say? I think the takeaway is if you are not abolishing a position, if you are just terminating someone for performance, including them in a RIF, and then you're going to hire 6 weeks later, a month later, they will find out. This will anger the person. It creates a situation where it seems as though there's been a misrepresentation. And I've often seen where what could have been a sort of smooth transition out of the organization becomes fraught and becomes a litigation situation because of the fact that a position has been filled shortly after the person left it. And so I think the message is just do be accurate, do be truthful in the way that you're characterizing a reduction. And if it's performance-based in part, if that is a criteria that is used, it's not a terrible idea to include that in your reasoning. And I think that's it for me, and I will turn it over to John.
Good, thanks. And let me just talk a little, I know we only have a few minutes left here, but let me just talk a little bit about documentation in terms of the reduction in force. So, a lot of times when you are doing a reduction in force, we're going to do documentation first, you'll get some pushback from leadership about documenting, right? And people just want to make the decisions. But I think somebody mentioned this earlier, if you don't have documentation, sometimes the decision makers will be gone by the time a lawsuit arises. Sometimes the statute of limitations might be as long as 3 to 5 years with respect to state claims. So you really want to have documentation. And I try to, create documentation that is easy for managers to use. A ranking template is oftentimes something where you can just rank the similarly situated people over consistent factors. And that way you can not only have the documentation and make sure you have a reasoned decision, but it's also fairly easy for the managers to use. And it promotes consistency when you're looking at the same issues like performance, like experience and skills, like education, like seniority. If they're ranked in the different categories, then that's an easy way for managers to do it. You want to make sure that you don't, though, when you're documenting, that you're not debating with each other with respect to the reduction in force, that there's nothing in writing where people are going back and forth in emails about who should be selected and who should be selected, because all of this is discoverable unless it's attorney-client privilege. And that's the other thing I think Ann might have mentioned a second ago. When you do the disparate impact analysis, when you do the legal review, you really want to make sure that you maintain the attorney-client privilege. So you have to make sure that you don't forward that information onto other managers when attorneys are not involved, because that could waive the attorney-client privilege. I want to just mention this. When I talk to HR professionals, they oftentimes tell me the very worst thing that they have to do in their careers is do a reduction in force. So this should be the first slide in our slide presentation, but you really want to think about other ways that you can do this, right? And you can do a hiring freeze. You can cut contractors and cut temporary employees right off the bat. You can transfer people to open positions. I think Lee talked a little bit about a voluntary workforce reduction. I like that. The one issue with respect to it is it involves even more planning, because what you have to do is you have to offer people the option to take a voluntary package, and then you have to build in time in the back end to do the involuntary reduction in force. So I think it's a good thing because it allows people to raise their hand and voluntarily leave. It helps morale, it cuts down on the potential for legal liability, but you have to really plan in advance for that. If you do a voluntary reduction in force, the question here is, what if your best performers resign? Communicate the practice or the procedure that you retain a right to veto somebody if they want to volunteer and they are a key or crucial employee, so you can say no to their volunteer. The one thing I would say is, if for some reason, right, somebody volunteers and you keep them as a key employee, do not use that against them moving down the pike, right? If you do an involuntary reduction in force or for other reasons down the pike, you cannot use that and take that adversely affect them. To finish it up, so our last slide, we want to make sure that, okay, if employees are on a leave of absence or if employees have made complaints, that does not necessarily immunize them from a reduction in force. A lot of times I'll get the question from HR professionals where they'll say, well, the person's on an FMLA leave or they're on leave of absence, I can't include them in the reduction in force. That's not true. You can include them in the reduction in force, but you have to have a really good reason. Same thing with respect to discrimination and harassment. If somebody's made a complaint, that doesn't mean that they are immunized or protected from the reduction in force, but it just makes it so we have to have even more certainty with respect to our decision. And the last thing I'll mention, be really careful about age discrimination. Oftentimes when we do a statistical study, it always shows that there's a disparate impact on older employees. And in that vein, make sure that you don't protect people who are quote unquote high potential, or protect or say, hey, we have to terminate this person because they're a blocker. I've had both of those terms used in class actions before, and you really want to make sure that you're careful about age discrimination in a reduction in force. I'll turn it over to Mark.
Thank you, everybody. We have, we're 2 minutes over. Let's do some quick questions. Number one, do individuals on furlough count towards the number of employees for calculating WARN?
Well, if they have only been on furlough for 6 months or less, No, but if they, well, it's more complicated than that, I suppose. If in fact they are going to be ultimately terminated, then they would count towards the people with respect to war. But as of the time of their furlough, no, because they haven't been permanently terminated, and they haven't been out for 6 months or more.
And one last question: if an attorney conducts an adverse impact analysis with the idea of keeping it privileged and determines that the results are favorable, would it make sense to then have the same analysis done by a non-attorney, say HR, or do you just choose to waive the attorney-client privilege?
I mean, I think that would be a matter of discretion. You could do it either way. I think given that the underlying facts are never going to really be privileged, it would probably be pretty easy for the in-house HR department to run the numbers in a way that then shows the favorable outcome that you want to. So you can kind of have it both ways. But I think it's susceptible to, reasonable minds could differ on this one.
Well, great. Thank you, everybody. We're now 3 minutes over. We thank everybody for attending this afternoon. And if you have any follow-up questions, the contact information of the attorneys is available. So please look forward for our other webinars that we will be conducting throughout the year. And if you have any ideas of a webinar you'd like to see, you can email me. Thank you very much and good afternoon.